Welcome to EduSet Network. Friend, as you know, this week we have organized a series of lectures on criminal justice in India. In the last lecture, we talked about the basic premises and the framework in which the justice is administered in India. Today, we will focus more about the procedure of investigation. What are the methods, what are the things which are kept in the mind while doing any kind of investigation of crime. That could be discussed in today's lectures. And for discussion on this very topic, we have in studio Professor Meenakshi Sinha. She is a senior faculty, one of the premier institutions of the country, that is Lok Nayak Jayaprakash Narayan National Institute of Criminology and Forensic Sciences. It's in Delhi. And I have already mentioned, studied, she has done double LLM, one from India, another from the United Kingdoms, and have also long practices of this kind of things, how the forensic sciences, criminology are carried out in country, the experience of that. So I hope his knowledge and experience will help us to understand this topic in a new perspective. So on your behalf, I welcome Professor Sinha for EduSet lecture on this very topic, procedure of investigation, and we'll focus how this is carried out in India. So on your behalf, I welcome Professor Sinha. Welcome.
Thank you, Dr. Amrendra, for giving me this opportunity to speak on these issues of criminal justice system. By way of giving the reference about our yesterday's talk on criminal justice system, today I will focus the first step, which is the procedure of investigation in India. As you all know, as soon as a crime is committed, the role of criminal justice functionaries starts, and first and the foremost role is the police and the investigation of the crime. Without the investigation, neither the trial can be committed, nor the prosecution can take place, nor the correction, nothing can be done. Neither the accused is punished, nor he is acquitted. Keeping all that in mind, we thought that let us have a first discussion about the basic procedure of investigation in India, so that as a common man, as a layman, everybody may come to know. And as I know that this is a very basic lecture, but I would like to focus on this subject. First, information report. As soon as a crime is being committed, the first information report is being lodged to the police station, FIR. The term FIR is very common among the common person, but FIR stands for first information report. Before we discuss in detail about the investigation, I would like to mention the definition of investigation as defined under the Criminal Procedure Code. Investigation means collection of evidence by police officer or any other person authorized by the magistrate. And as I can also tell that the main purpose of investigation is to collect the evidence for the purpose of trial. Power of investigation by police is defined under various sections under Chapter 12 of Criminal Procedure Code 1973. Before we discuss about the power of investigation, I would like to tell you in brief about the criminal law in India. Mainly, the criminal law consists of minor and major acts and codes. So, minor acts are, you see, local and special laws which is enacted for a special purpose or which have been enacted in a special state. Major codes are Indian Penal Code, Criminal Procedure Code and Indian Evidence Act. In Indian Penal Code, various offences have been defined and the punishment has been incorporated. So, that is a specific and a substantive legislation. The criminal procedure code is the procedure, and all the procedure is defined to proceed to the court and to take the step for each and every aspect required for making anybody criminally liable. Role of Evidence Act is to suggest and help the admissibility of evidence. Like admissibility means कि हम किस चीज़ का एविडेंस दे सकते हैं, किस चीज़ का नहीं दे सकते हैं, what can be accepted in the court of law, what is not accepted in the court of law, how to produce the evidence. Because I told you yesterday that in adversarial justice system, the conviction or the acquittal is based on evidence. So that is defined in Indian Evidence Act. Now I will come back to my main point, that is investigation. And according to Criminal Procedure Code, which I have told you defines the procedure, it is a procedural law. In a cognizable case, police can investigate case without the order of magistrate, while in a non-cognizable case, police cannot investigate the case without the order of the magistrate. Now you may ask me one question, that what is the cognizable and non-cognizable offence? Usually cognizable offences are those offences which have been defined as cognizable under the schedule of the court, and non-cognizable as well. And cognizable offences are those offences in which police can take action immediately, and in non-cognizable police cannot take action immediately without the order of the magistrate. Now the basic reasoning behind keeping some offences as cognizable and some offences as non-cognizable is that non-cognizable offences are usually those offences where immediate action by the police is not required, while in a cognizable cases the immediate action by the police is required. So suppose if somebody calls up on a 100 number, which all of you must be knowing is a police control room number, and tells ki a terrorist has entered into the country, then what will you do? That is a cognizable offence, because immediately police will go to the spot and take the action. So like that, you see, that is the heinousity, the gravity and the importance and the impact on the society makes any offence cognizable and non-cognizable. And by way of amendment, their categorization of the offences as cognizable and non-cognizable offences keep on changing. Every information relating to the commission of a cognizable offence, if given orally to an officer in charge of a police station, should be reduced to writing. The first and the foremost step is that as soon as you go to lodge an FIR to a police station, what you have to do, first of all, you should write down your complaint and your grievances on a piece of paper, addressing to the station house officer, like to the SHO police station, naming the police station of the locality so and so, ये मेरे साथ हुआ है, ऐसा हुआ है, ऐसा हुआ, all narration of the brief facts which have taken place, and praying that necessary action should be taken, and the name and address of the victim or the complainant should be written. In many cases, FIR is not being given in writing, and certainly a person goes to a police station and tells that something has taken place and they want the action. In that case, the head constable and the person who is writing the FIR, he should reduce it to the writing, and after reducing it to the writing in their own case diary, the copy will be given free of cost to the informer. Read over to the informer. When they will reduce the content of the FIR in their own notebook, they will read it, and the informer has got every right to listen it. As a common man, you must know कि अगर आप पुलिस स्टेशन जाते हैं, FIR कराते हैं, तो आपके क्या अधिकार हैं. दूसरा, you should sign the copy. It should be signed by the person giving it. The substance should be entered in a book to be kept by the officer, that is usually called the case diary. The substance, the brief fact of the cases are entered into the register, and then the photo state are but the carbon copy of that entered substance which has been entered in the register are given free of cost to the informer. Now I would like to tell you that whenever you lodge an FIR, make sure that you are getting the state copy of the registered FIR, and they put a number over it. If anybody would like to ask any question, any query, otherwise I will proceed further. The proceeding to crime scene. The moment the FIR in a cognizable case is being lodged, the police officer immediately proceeds to the crime scene to investigate the facts and circumstances of the cases. Crime scene means the place where the crime has taken place. Then takes the measures for discovery and arrest of the offender after reaching crime scene. As soon as a police officer reaches to the crime scene, you must watch that what he is doing, and you should watch him closely, that he will take the measures for the discovery and arrest of the offender after reaching the crime scene. The moment they reach to the spot where the crime has been committed, the police officer will take the measures for discovery and arrest of the offender and see that how the offender can be arrested. Suppose if the offender is present there, they will immediately arrest. If he is absconding, he is running here and there, and he is visible, then he will be arrested. Otherwise, they will go and search the offender and arrest him. Officer who first proceeds to the spot, if he is not competent to complete the investigation, takes all his steps to preserve the crime scene from the disturbance. In many cases, you see what is happening, that sometime officer is proceeding to a spot, and the person who has been directed by the SHO to go to the crime scene, he may not be eligible to conduct the investigation. Maybe a lower officer, a police constable who is not delegated the power to investigate the cases, he will take all his steps to preserve the crime scene from the disturbance. First of all, and the foremost important thing is that one should immediately preserve the crime scene. Preserve the crime scene means that it should not be disturbed. Nobody should come and touch anything. Even touching will make a lot of difference, because if the fingerprint is being lifted up and somebody is touching it, then it is making lot of difference. So it should not be that. Then IO records particulars of the crime scene and secure the presence of potential witnesses and obtain information relating to the case. First step is to take the to conduct the arrest, if arrest, and that is one procedure going on. Besides preservation of the crime scene, then securing the presence of potential witnesses and obtaining information relating to case. That in a layman's language I can say that पूछताछ करना लोगों से. When a person is reaching to a place where the crime has been committed, he will ask people क्या हुआ, कैसे हुआ, क्यों हुआ, किसने, तुमने कुछ देखा, उन्होंने कुछ देखा, लोगों की लोकेलिटी में बातचीत करना, सस्पेक्ट से क्वेश्चन करना, जो कॉमन लोग हैं उनसे पूछना, and taking a clue for the further investigation. So these are the certain points at the crime scene which is the most important steps. If any person aggrieved by a refusal on the part of an officer in charge of a police station to record information relating to offence, may send the substance of the information in writing and by post to the superintendent of the police concerned. Now who can lodge the FIR? I was telling after lodging the FIR you have to go to the police ka role hai ki they will go to the crime scene, preserve, arrest and all those things. Now again the question is ki who can lodge the FIR? A aggrieved person can lodge the FIR, but if the aggrieved person who is suffering from non-receipt of the FIR, एक बहुत common complaint आती है कि जनाब पुलिस FIR नहीं लॉस करती है. I would like to inform, if that is the situation and the police is refusing to lodge the FIR, then the offender may send the substance of the information, the brief facts of the cases by post to the superintendent of police to the area concerned in whose jurisdiction the crime has taken place. And I think that common people sometime ignore this fact और वो request करते रहते हैं पुलिस स्टेशन पर. ऐसा नहीं है. उसको रजिस्टर पोस्ट से आप भेज दें and SP has to take the action over it. The superintendent of police, either he will investigate the case himself or direct an investigation to be made by any police officer subordinate to him. That is a very important issue. And for example, I would like to tell you, in many cases we come to know FIR देर से लॉज हुई, FIR नहीं लॉज हुई, पुलिस तो FIR ही नहीं लॉज कर रही, ऐसा नहीं होता है. We should know our right and duties. For example, I tell you, long back, I mean last year, there was a case in Daryaganj, there was a case in a blue line bus where a robbery has taken place at 11 o'clock in a blue line bus in the city of Delhi, which was going from Mayapuri to Janakpuri, somewhere on the way. Then the people go to lodge the FIR, the nearest police station say no, that bus is moving and the crime scene has taken place when the bus has already crossed the area of their jurisdiction. Then the victims went to another police station, it was refused. After 2-3 times of refusal, at 4 o'clock the FIR could be lodged in a Mayapuri police station. So it is a harassment, and the police is also not mistaken in this situation, because they have to follow the law, and law defines that the crime will be the crime is committed in a particular jurisdiction. But in that situation, nobody bars to receive the FIR, and instead of rushing from pillar to post, one should go to the superintendent office, ACP office, DCP office in a metropolitan area and give the complaint. If they cannot go, one should go to the post office and register the case and send it by the post. Officer in charge of a police station send a report after lodging the FIR to a magistrate empowered to take cognizance of the case. Again, the duty that if officer in charge after lodging the FIR, a person will go to the crime scene and the copy in parallel will be sent to the magistrate concerned. Now, I was discussing about the arrest. After reaching the crime scene, if the police is going to make the arrest, what are the procedure to be followed in the arrest? That is one of the component of arrest, and I am exclusively telling you the procedure of arrest. At the time of making the arrest, it is necessary that IO, investigating officer, should bear an accurate, visible and clear identification of his name for the purpose of easy identification. Prepare a memorandum of arrest which is to be attested by at least one witness who is a member of the family of the person arrested or a respectable member of the locality where the arrest is made. You see, in a crime scene, even if a criminal is there, he's not, and the police is arresting, then arrest memo has to be prepared, and that one witness should sign there, either the member of the family arrested or the respectable member of the locality where the arrest is made. And where the witness is signing, that memo should also be signed by the person who is arrested. Then the arrestee should be informed about the cause of acquisition. The cause of acquisition means कि उसको हम क्यों accuse कर रहे हैं, उस पे हम क्यों शक कर रहे हैं, उसको हम क्यों arrest कर रहे हैं, इसका reason भी उसको बताना पड़ेगा. Unless the memorandum is attested by a member of his family, the suspect has a right to have a relative or a friend named by him to be informed of his arrest. अगर अरेस्ट मेमो पे फैमिली मेंबर के सिग्नेचर नहीं है तो सस्पेक्ट को एक अधिकार है कि उसके फ्रेंड या रिलेटिव को इन्फॉर्म करे. ऑफिसर मेकिंग अरेस्ट में सर्च अरेस्टी, place in safe custody all articles other than necessary wearing apparels found upon him. If any article is seized from the arrested person से जो भी आर्टिकल आपको मिलेगा उसको सीज करना होगा. सीज करने का मतलब है कि they will be packed in a piece, in a some you see proper packet or whatever may be, and that will become the part of investigation and produced in the court of law. And whatever things have been searched and found during the arrest from the body of the person or nearby place, that will be seized, and a receipt showing the articles taken in possession by the police officer has to be given to such person. कि भाई तुमसे ये सामान लिया, ये सीज किया, ये रसीद है, यानी हमने ये चीज तुम्हारा अपने पास संभाल के रखा है. Then investigating officer may also take offensive weapon from the person arrested. If a person is carrying out any offensive weapon, like you see revolver, chaku, anything, then that the person who is making arrest, the IO has to take in his custody. Examination of arrested person is done by medical practitioner. Suppose if you arrest a person and उसको चोट लगी है, इंजरी हुई है, भाग रहा था, कुछ भी है, तो उसका एक मेडिकल एग्जामिनेशन करवाना पड़ता है. Because to know that when he was arrested, he was hale and hearty, or he was suffering from some problem, but that is important aspect. Then a police officer cannot retain any person in police custody more than 24 hours of the arrest, excluding the time of journey. अगर एक पुलिस स्टेशन में किसी को अरेस्ट किया है तो उसको 24 घंटे से ज़्यादा नहीं रख सकते हैं, उसको भेजना पड़ता है कोर्ट में. लेकिन ये 24 घंटे का समय जर्नी आवर को एक्सक्लूड करके जोड़ा जाता है. सपोज आप किसी आदमी को अगर दिल्ली में अरेस्ट करें और उसको आपको कलकत्ता भेजना है, तो वहाँ तो भेजने में ही ट्रेन से 24 आवर से ज़्यादा लगेगा, तो दिन दैट केस वो जर्नी टाइम एक्सक्लूड हो जाता है. If the suspected accused is absconding and warrant is not getting executed, in certain cases what is happening that suspected accused is absconding, accused भाग गया है, मिल नहीं रहा है, and वारंट भी एग्जीक्यूट नहीं हो रहा है. जब अक्यूज्ड एब्सकॉन्ड करता है तो पुलिस वाला जाके मैजिस्ट्रेट से रिक्वेस्ट करेगा और वो एक वारंट बनाएगा. अब वारंट को एग्जीक्यूट करने का मतलब ये है कि उसका एड्रेस वगैरह पे पुलिस जाके उसको घर से अरेस्ट करेगी. इफ घर में भी वो नहीं मिलता है, भाग गया है, उस सिचुएशन में कोर्ट में इशू रिटन प्रोक्लेमेशन रिक्वायरिंग हिम टू अपीयर एट द स्पेसिफाइड प्लेस एंड टाइम. और अगर उस पर वो नहीं मिलता है इन सेक्शन 82, देन द प्रॉपर्टी कैन बी अटैच्ड. सपोज अगर हम एक घर के ओनर हैं और हम चोरी करके भाग जाएं तो कोर्ट हमें ऑर्डर कर सकती है कि हम आपका सारा घर सीज कर देंगे, उसको अटैच कर देंगे और जब तक आप नहीं आएंगे. एग्जामिनेशन ऑफ विटनेसेस, इन्वेस्टिगेटिंग, दैट इज वन ऑफ द स्टेप विच आई टोल्ड यू, द अरेस्ट, that is a part of investigation. The moment you move to the crime scene, one procedure I have told. Another I have discussed you, second step, that is examination of witnesses. Examination of witnesses, we should not confuse this with the examination of witnesses in the court of law. Examination of witnesses, that is investigating officer may examine orally any person supposed to be acquainted with the facts and circumstances of the case. Such person shall be bound to answer truly all questions relating to such case put to him by the investigating officer, and the concerned investigating officer may reduce into writing a statement made to him in the course of an examination. This is the procedure which I have discussed कि वो लोगों से पूछताछ करेगा. This is called examination of witnesses. और अगर पुलिस किसी से भी कुछ पूछती है क्राइम के विषय में तो उसका जवाब देना हर नागरिक की ड्यूटी है. Whatever is being examined, that has to be written. Now, another requirement is spot map. When a person goes to the crime scene, he preserve the crime scene, उसको एक वहाँ का मैप बनाना होता है. The map will incorporate कि यहाँ कौन डेड बॉडी कहाँ पड़ा था, चोट कहाँ लगी है, ब्लड कहाँ गिरा है, who is, what is where. That is very important, and that is called a spot map, the map of the crime scene. And this has to be prepared either by investigating officer or any other qualified person. पुराने ज़माने में पटवारीज used to help in preparation of the map. Suppose if the IO is not able to prepare the map properly, he can take the help of any expert. Like you see, आपको आईओ को ये नहीं मालूम है लैंड किसका है, उसके नॉर्थ में क्या है, साउथ में क्या है, वॉट एवर मे बी, तो देन ही कैन टेक द हेल्प ऑफ एक्सपर्ट. बट द मैप हैज टू बी प्रिपेयर्ड इन 2 copies. One copy is submitted with the charge sheet and another copy is retained by investigating officer for departmental use. Charge sheet I will tell you later, but मैप की एक कॉपी डायरी में रहेगी, एक चार्जशीट के साथ लगेगी। लिफ्टिंग फॉरेंसिक एविडेंस, then there is an important aspect that lifting up of the clue from crime scene. As you all know that with the changing trend of society, increasing complexity of society, the crime trend has also changed, and with the changing crime trend, it has become important to take the scientific clue to investigate a case, to reach to the actual culprit. In that situation, forensic science has got an important role to play. I would not like to go much into detail about forensic because this is a lecture on law. Investigation officer who with the help of technical expert lift the forensic exhibits and get crime scene photography done. Expert opinion on following subject may be taken during the investigation. As a part of investigation, forensic photographers, they will take the photography of the crime scene. स्पॉट मैप के साथ वो फोटो भी अटैच करते हैं जिससे ये समझ में आता है क्या चीज़ कहाँ पड़ी है. हैंड राइटिंग एक्सपर्ट में टेल कि ये हैंड राइटिंग किसका है अगर कोई डाउट है. फॉरेंसिक बैलिस्टिक एक्सपर्ट ये बताएगा कि कार्ट्रिज कौन सी यूज़ हुई, गोली कितना दूर से चली, क्या हुआ, कौन से वेपन से वार हुआ है, वॉट में भी. केमिकल एनालिस्ट है, वो बताएगा कि वेदर ए पर्टिकुलर मैटर इज गन पाउडर आर नॉट, वेदर इट इज पॉइजन आर नॉट. लिफ्टिंग ऑफ फिंगरप्रिंट एंड फुटप्रिंट, अक्यूज्ड के पैरों के निशान, हाथ के फिंगरप्रिंट लिफ्ट करेगा. डॉक्यूमेंट एक्सपर्ट फोर्जरी के विषय में बताएगा. मेडिकल जूरिस्ट विल कंडक्ट द पोस्टमार्टम ऑफ द डेड बॉडी एंड टेल द कॉज ऑफ डेथ, द टाइम ऑफ डेथ and the other factors whatever medical may be possible. Lie detection is a recent development where the suspect is being interrogated by a lie detector and he can try to tell that whether he is speaking lie or whatever, and they can give a clue to the investigating officer. Then DNA analysis, then brain mapping, brain imaging, brain fingerprinting, bringing somebody in a trance stage and come to know what is hidden in his mind and to take it out. So here comes the role of forensic science, and I would not like to go into detail, but lifting up of the forensic and evidence and exhibit is one of the aspect. Now, examination of crime scene, arrest, lifting up of the evidence, making the crime scene photography. Another issue is search. Suppose investigating officer goes to a crime scene and at the crime scene he is finding that something is to be recovered from a place, may be found at any place, relating to investigation only, nothing else. After recording and writing the grounds of his belief, the IO will write down the ground of his belief कि वो क्यों ऐसा शक कर रहा है कि पर्टिकुलर आदमी ने अपने घर में पर्टिकुलर चीज़ छिपा के रखी है, लाइक वेपन छिपा के रखा है, कपड़े छिपा के रखे हैं, ड्रग छिपा के रखा है, कुछ भी छिपा के रखा है. And specifying in writing so far possible the thing for which search is to be done. And but before making search in anybody's house, he has to write down everything on a piece of paper, and then he may search for such thing. As far as possible, search has to be conducted in person. Officer or other person about to search should call two or more independent and respectable inhabitants of the locality in which the place to be searched is situated. The moment the officer goes to make a search at the place of a person, किसी के घर जाते हैं तो उन्हें वहाँ के एक दो लोगों को बुलाना होगा. और अगर वहाँ से कोई नहीं आ रहा है, if no such inhabitant of the said locality is available or willing to be the witness, which usually people avoid in India, thus he may issue an order in writing to the people that you please come and become a witness. And the list after making the search, whatever suspect thing is found, that will be recovered and that will be seized. And the list of things seized will be prepared and signed by the police officer and the witnesses who are available जिनके सामने सर्च हुआ है, सामान सीज हुआ है, and the investigating officer has to send the copies of record prepared during search to the nearest magistrate who is empowered to take cognizance of offence. वो उसका लिस्ट तुरंत मैजिस्ट्रेट की कोर्ट में भेजना पड़ेगा और एक कॉपी चार्जशीट के साथ लगेगा. The owner or the occupier of the place searched on application we furnished free of cost with a copy of the records prepared by police and by the magistrate. This was all about the search. Now, another procedure of investigation is seizure. Police may seize any property which may be alleged or suspected to have been stolen. Proceed of crime. You see, with the changing trend of crime, lot of illegal money is being generated out of the crime. बहुत सारी इलीगल मनी इकट्ठा हो रही है. आप लोगों ने हवाला के विषय में सुना होगा. You might have heard about money raised out of drug trafficking, money laundering. Abhi black money case is pending where the money is being kept in lot of Swiss bank account. So what is happening that not only money, any other things also, अगर किसी ने कार चुरा के घर में रखी है तो सबसे पहले जब ये पता चलेगा कि ये प्रॉपर्टी क्राइम के द्वारा इकट्ठा की गई है, that property has either been purchased out of the money collected from the crime, that is the proceed of the crime, or the money is coming out of the crime, or the money or the goods are stolen, then the police can seize that property under section 102 of Criminal Procedure Code. First of all, I would like to give an example of what the seizure mean. Suppose the bank account of the accused or any of his relation constitutes property within the meaning of section 102 of Criminal Procedure Code, and police officer in course of investigation can seize the operation of said account if such assets have direct link with the commission of the offence for which the police is investigating into the case. अगर वो बैंक में पैसा क्राइम का है उसका कमीशन, जैसे स्विस बैंक में फॉर एग्जांपल इन ब्लैक मनी केसेस अगर प्रॉपर्टीज भी अगर ये लग रहा है कि वहाँ पे काला धन लोगों ने जमा किया तो सबसे पहले उसको सीज किया जाएगा. दैट मीन्स कि द ऑपरेशन ऑफ द अकाउंट विल बी स्टॉप्ड बाय द अकाउंट होल्डर. He can neither deposit any extra money in the account nor he can withdraw any money from the account. There are a lot of cases on these all aspects of investigation, but I will not like to go into detail because that would be more technical lecture. This was laid down by the court, that is Apex Court and Honorable Supreme Court of India in a case State of Maharashtra versus La Paz de Nivogi in the year 1999. The citation is 7 Supreme Court cases, 685 is the page number. The case was also reported in AIR in scale, and in scale it was reported in 1995, 5th volume, and page number 613. आप लोग अक्सर बात सुनते होंगे रिमांड. रिमांड आखिर है क्या? I would like to tell what remand is. If the investigation cannot be completed within 24 hours of arrest and the investigating officer believes that accused has useful information, and you know कि 24 hours में तो कभी भी investigation complete नहीं होता है, that is not possible. तो रिमांड तो होना ही होना है. The SHO, Station House Officer or Investigating Officer IO may request magistrate for giving the suspect on remand. तो वो जाके कोर्ट में एक अर्जी लगाएगा and then he will request that please give the suspect for the purpose of interrogation, and magistrate if permits the remand will be done and the accused will be given in the custody of the police where he will interrogate him, but that will not be granted at one time for more than 15 days. 15 दिन से ज़्यादा की एक बार में रिमांड जनरल केसेस में नहीं मिलती है. अगर 15 दिन में नहीं होता है तो अगेन रिमांड का टाइम बढ़ता है, उसमें वो रहेगा प्रिजन में बट पूछताछ होगी। 90 days where the investigation relates to an offense punishable with death, imprisonment for life or imprisonment for a term not exceeding less than 10 years। अगर हीनियस ऑफेंस है तो 90 days का 2-3 बार में हो सकता है। If the investigation relates to any other offense not heinous as mentioned above, the 60 days, that is the largest term for a remand. On the expiry of the set period of 90 days or 60 days as the case may be, the accused person shall be released on bail if he is prepared to and furnish bail bond as required। इससे ज़्यादा उसको नहीं रख सकते हैं रिमांड पर। रिमांड इसलिए ज़रूरी है क्योंकि पुलिस को इन्वेस्टिगेशन करने के लिए अक्यूज से बातचीत तो करनी पड़ेगी, और अगर वो रिमांड नहीं लेगा तो वो जेल में जाके उसको इंटरेक्ट नहीं कर सकता है, और फिर कैसे क्लू कैसे मिलेगा। बट सवाल ये उठता है कि रिमांड कितने लंबे समय के लिए दी जाए, इसलिए सीआरपीसी हैज ऑलरेडी पोज्ड अ रिस्ट्रिक्शन दैट रिमांड कैन नॉट बी एक्सटेंडेड फॉर मोर देन अ टाइम which is specified. Here I would like also to mention that this time of remand is for general cases. In certain special cases, the time of remand is being increased, 160 days in organized crime cases and in other cases as well. केस डायरी, अभी इन द बिगनिंग हम आपसे बात कर रहे थे केस डायरी के विषय में कि वो केस डायरी में FIR के कंटेंट को लिखेगा। नाउ व्हाट केस डायरी इज, दैट इज अ इम्पॉर्टेंट पार्ट ऑफ एनी इन्वेस्टिगेशन, वेरी इम्पॉर्टेंट पार्ट। Investigating officer have to enter proceedings of investigation, day-to-day proceedings of investigation in the case diary. In that he has to write down that at which information, at what time he has reached, what time he has started the investigation of the case, where he visited, and a statement of the circumstances as certain through his investigation. उसको एक एक चीज़ उसमें मेंशन करना होगा कि आज 10 बजे मैं स्पॉट पे गया, आज 11 बजे मैं इस विलेज में गया, एंड आई हैव टॉक टू दिस पर्सन, आई स्पोक टू मिस्टर राम, आई स्पोक टू मिस्टर श्याम, and then he will narrate that Mr. Ram and Shyam has told this and I draw this inference, now I will further proceed. You see why this is important, to bring a transparency in the system and to stop the misuse of the police power. So now we keep on blaming the police, but that is wrong, you know. Why? Because पुलिस के हाथ तो हर तरफ से बांध दिए गए हैं, वो अपने मन से कुछ नहीं कर सकता है। कितना झूठ चीजें वो केस डायरी में मेंटेन करेगा, नहीं पॉसिबल है। डे टू डे हाउ अ पर्सन कैन मेंटेन अ केस डायरी बाय स्टेटिंग द रॉन्ग फैक्ट. So one is accountable, and the case diary is a kind of a mirror of the whole investigation procedure, and that becomes the part of a charge sheet when it is filed to the court of law. Therefore, it is very important aspect of a criminal investigation, and technique of writing a case diary is very important, and that is being taught to them during the training. Any criminal court may ask for the police diaries of a case under inquiry or trial in such court, and may use such diaries not as a evidence in the case but to aid it in such inquiry or trial. At any time court can ask the case diary, वो देख सकती है case diary, not as a evidence but an aid in inquiry or trial. उससे inference draw करेगा, देखेगा, but that is not used as a part of evidence. When a case is sent for trial, the case diary shall be forwarded with the challan to the magistrate, and on the completion of the trial shall be returned to the police station for record, as I have told you earlier. Completion of evidence. When the investigation is completed, after completing investigation, insufficient evidence is found, and it is found that accused is not guilty, then he may be released. If the evidence is sufficient, charge sheet is prepared and filed in the court of concerned magistrate. Under section 173 of CRPC, on completion of the investigation, the charge sheet is filed. The charge sheet is nothing but a police report which is prepared by way of tedious job of investigation. That charge sheet or the challan or the police report has to contain the following articles, following matters. Number 1, the officer in charge, the SHO, forwards to magistrate empowered to take cognizance of the offence a report. The report will be submitted in the court of magistrate who takes the cognizance. Names of the parties are included in the report, nature of the information that are relating to what crime, how they have received the information, whether the information is relating to a cognizable case or a non-cognizable case, whatever may be. Names of the person who appear to be acquainted with the circumstances of the case. What are the name of the people who are acquainted with the circumstances of the case? Whether any offence appears to have been committed and if so, by whom? Whether the accused has been arrested, whether he has been released on personal bond with or without surety. जब अक्यूज्ड अरेस्ट होता है तो अगर छोटा सा ऑफेंस हो तो पुलिस उसको पर्सनल बॉन्ड पे रिलीज करता है, नहीं तो उसका सरेंडर होता है. आफ्टर द सरेंडर बेल एप्लीकेशन इज फाइल्ड एंड द बेल इज ग्रांटेड are not granted. That depends on whether offense is bailable, non bailable. Bailable या non bailable का मतलब ये नहीं है कि उसको बेल नहीं मिलेगी. Whether the offense is bailable or non bailable. Even if offense is where the offense is bailable, police has got a right to relieve on the bail. But if offense is non bailable, the one has to go and put a bail application in the court of law, and it is the court of law who will decide whether the bail has to be granted or not. The more the heinous offence is, the more a cognizable crime is, the more a non-bailable offence is, the more difficult is to get a bail. But even in non-bailable cases, it is not the thumb rule that bail will not be granted. But with lot of difficulty, maybe a bail application is refused from the magistrate's court, then the will be filed in sessions court, in higher court, in high court and the Supreme Court as well. If a bail is refused from the Supreme Court, no way out to come out of the prison, like in many cases. Whether he has been forwarded in custody, that information will also be kept in the charge sheet. The officer shall also communicate the action taken by him to the person, if any, whom the information relating to the commission of the offence was first given. When such person is in respect of a case where evidence is sufficient, the police officer shall forward the accused to the magistrate empowered to take cognizance of the offence upon a police report and to conduct trial along with the report. If they find that evidence is sufficient, the accused will also be sent to the court of magistrate along with the report. All the documents are relevant extracts on which the prosecution proposes to rely other than already sent to the magistrate during investigation will also be sent along with the police report. The statements recorded of all the persons whom the prosecution proposes to examine as its witnesses. All the examination which have been done, all the statements, case diary, statement, challan and every report, every memo, everything along with the accused will be sent to the magistrate. Now, I again would like to ask you if anybody has got any question, any query. No question. Now, I would like to tell you the further provision, what has to be done thereafter. Thereafter, the trial will start, that is about the cognizable case. Now I would like to tell you in brief about the non-cognizable cases. In a non-cognizable cases, the complaint after getting it received by a police station, the content immediately are not reduced to the register of the police, and the photostat copy of the content of the application are not bound to be given to the informer. The police will keep the complaint, and the police station in charge will forward the copy of the complaint to the concerned magistrate in whose area, in whose jurisdiction the crime has been committed. Then the magistrate will examine the application. If he desires so he may call the witnesses. Then he will decide whether there is any need to conduct the inquiry or investigation in a particular case, or there is no need. In that situation, the magistrate can take his own action, and after hearing a basic hearing, he may decide, and if he feels that further investigation is required, he may send the complaint along with the direction to the concerned police station, where the station house officer will start the investigation. Whether it is a cognizable case or a non-cognizable case, the procedure of investigation is same. If the order of the complaint, the magistrate includes the warrant, then the arrest will be made in a same way. If the accused is absconding, the order of the arrest will be issued, the property may be attached, and the similar pattern, arrest memo will be prepared, search will be conducted, seizure will be conducted. The person will go to the IO, may go to the crime scene, though the crime scene might have been got spoiled, but the procedure is whatever possible is similar. Thereafter, the charge sheet is filed to the court of law in non-cognizable cases also, if the investigation is conducted under the order of the magistrate. And then after filing the charge sheet, the trial starts. Now there are few other aspects which is relating to investigation, that is confession. Well, during the interrogation, if it is found that some important facts are hidden and accused feel guilty and he want to confess, कई बार ऐसा होता है कि कोई गुस्से में किसी को मार देता है और जाके आपने न्यूज़पेपर में पढ़ा होगा कि वो इस आदमी ने कन्फेस कर दिया, सरेंडर कर दिया और जाके अपना अपराध कबूल कर लिया। या कई बार न्यूज़पेपर में आप लोग ने देखा होगा कि वो हस्बैंड हैज किल्ड हिज चाइल्ड, 5-6 लोगों ने एक साथ एक दूसरे को, परिवार के लोगों को मार के खुद जो है कोर्ट में हाजिर हो गए, देन दैट इज अ कन्फेशन। बट कन्फेशन made in police custody is not admissible to the court of law. Confession made in court in front of the magistrate is admissible to the court of law. Admissible means that उसकी value है, otherwise उसका कोई value trial में नहीं होगा. Then confession may be recorded by the magistrate or a judicial magistrate or a metropolitan magistrate. Judicial magistrate और metropolitan magistrate के विषय का अंतर तो आपको मालूम होगा, because yesterday I have talked a lot on this issue. May record the confession means may note down whatever accused is telling under the free will of accused. The most important component of a confession is that it should be made voluntarily, free will, and without any pressure. And the magistrate will tell to the accused ki, look, if you are getting a confession done and if I am recording the confession, it may be used against you. Means in the court of law it may be used against the person, and even then the accused say ki, no, I want to confess. Then the magistrate will record the confession, and the confession statement, whatever is written by the magistrate, that will be signed and read over by the person who is confessing his guilt. जो अपने क्राइम को, अपने अपराध को, अपनी गलती को महसूस करके बता रहा है, उसको वो स्टेटमेंट साइन करना पड़ेगा। This is what about confession. Now the relevancy of the confessional statement and all will be discussed in another lecture. For investigation purpose, I just wanted to tell you in brief. Then another is dying declaration. A dying declaration is also an important component. When dying declaration means if under all probability of death a person want to tell something, that is called dying declaration. Hindi mein we call it a kalam band bayan, means the dying declaration does not need to be corroborated, the evidence that the witnesses does not need to be examined. Dying declaration itself is a full proof statement on the basis of which a conviction may be recorded. Whenever possible, be recorded by a magistrate. Dying declaration is recorded by the magistrate. The person making the declaration will be examined by a medical officer with a view to ascertaining that he is sufficiently in possession of his reason to make a lucid statement. That first of all, he is sound minded person, his health is no doubt bad because he is at the deathbed, but he is in a position to speak true at least, and then also his all probability that in all probability he is going to die. The main use of dying declaration is that the person should die after the declaration. अगर वो dying declaration के बाद इंसान बच जाता है तो उस पर conviction नहीं होगा. ये एक बहुत पुराना concept है. The concept is based that on a belief कि जो आदमी मर रहा होगा वो झूठ नहीं बोलेगा. And the person should have a belief that he will die. If no मैजिस्ट्रेट कैन बी ऑब्टेन, सपोज किसी की बहुत हालत खराब है, गोली लग गई है, वहाँ मैजिस्ट्रेट नहीं है, देन द डिक्लेरेशन व्हेन अ गजेटेड पुलिस ऑफिसर की प्रेजेंस में नोट किया जाता है. सपोज इफ अ गजेटेड पुलिस ऑफिसर इज ऑल्सो नॉट प्रेजेंट देयर बिकॉज सडनली सम गोली किसी को लगा और वो मर रहा है और वहाँ पे वो भी नहीं है, then it will be recorded in the presence of 2 or more reliable witnesses unconnected with the police department and with the parties concerned in the case. Then in that situation the dying declaration will be recorded in presence of some witnesses. अकेला एक कोई आदमी डाइंग डिक्लेरेशन रिकॉर्ड करके, वो भी मैजिस्ट्रेट नहीं है, गजेटेड ऑफिसर अगर नहीं है, तो दैट विल नॉट बी एक्सेप्टेड इन द कोर्ट ऑफ लॉ ड्यूरिंग द ट्रायल, उसकी कोई वैल्यू नहीं होगी. If no such witnesses can be obtained without risk of injured person dying before his statement can be recorded. अगर witnesses भी नहीं मिल रहे हैं तो फिर वो statement record किया जाएगा, but the sufficient reasons has to be given for that. It shall be recorded in the presence of 2 or more police officers. Then at least there should be more than 2 police officers. You see, all this is done because they want to make a check and balance कि कोई arbitrariness ना हो. A dying declaration made to a police officer should under section 162 CRPC be signed by the person making it. Again, as I have told you, whether it is confession, it is dying declaration, it is a statement of the witnesses, everything has to be read over by the person and he should sign, and while signing it is presumed that he has done it under no influence, no duress, undue influence or coercion, and he is doing it willfully. There is another exception, that inquiry and report on suicide. If the officer in charge of a police station or some other police officer especially receives information that a person has committed suicide or killed by another or by any animal or by any machinery or by accident, or he has died under circumstances which is raising a doubt, which is a suspicion case, immediately the intimation will be given by the police officer to the executive magistrate who is empowered to hold the inquest. Inquest means inquiry into cause of death. In case of suspicious death including suicide and another reason to, and the magistrate and then the SHO should go to a spot and he should prepare a report and forward the report to the district magistrate, because executive magistrates are DM and ADM and SDM. If a woman died within 7 years of marriage, this is inserted by way of recent amendment when dowry deaths have been taking place and Dowry Prohibition Act has been enacted in India. If a woman died within 7 years of marriage, a person died in custody, custodial death, dowry death, the body shall be forwarded to nearest civil surgeon for the examination also. An inquiry is conducted by the magistrate. The magistrate will go to the scene, he will see the body, he will conduct the inquiry, that is in suspicious cause of death. Now, there are certain special provisions under certain special laws besides the legislative provision of investigation which is used in traditional crime are the common procedure. I would like to tell you that in Maharashtra Control of Organized Crime Act 1999, which permits the interception of wire, electronic or oral communication of a suspect, but there are lot of checks and balance. जैसे आप कहते हैं ना कि वो टेलीफोन में बात कर रहे थे, टेलीफोन का इंटरसेप्शन, बट द फोन इंटरसेप्शन इज नॉट परमिसिबल इन एवरी लॉ एंड इन एवरी केस. दैट इज परमिसिबल इन महाराष्ट्र कंट्रोल ऑफ ऑर्गेनाइज्ड क्राइम एक्ट, इन अनलॉफुल एक्टिविटीज प्रिवेंशन एक्ट, वेयर बाय वे ऑफ अमेंडमेंट द प्रोविजन ऑफ POTA, which was Prevention of Terrorism Act, have been inserted to prevent and control the terrorism, because they say that terrorism is also one of the unlawful activity and it is a heinous offence and it is a crime against the state and a central legislation is required. So, in many other cases also it is permitted, but obviously certainly not in every cases. And when wire, electronic and all these are being intercepted, there are a provision that who will permit, who will commit and how that will be done. I would not like to go into detail, I just wanted to give you a bird's eye view about this. Then the police officer conducting the investigation should not be below the rank of the Deputy SP or the ACP. Maharashtra Control of Organized Crime Act is a special legislation, that is a local legislation in Mumbai, or it is Mumbai, and it is enacted in, notified in Delhi also. So, there the ACP and above have been given the power to investigate. The same is Prevention of Unlawful Activities Prevention Act in sometime in drug related cases, in many other cases also. Then I would also like to point out here that examination of rape victim, if a rape is being committed against a woman, that will be conducted by a registered medical practitioner by any government hospital. So, and thereafter I would also like to tell that in certain cases, like in organized crime cases, the period of remand has been extended from 90 days to 160 days, and then the other provisions are also there in these type of heinous offences, while with apart from these heinous offences like organized crime, terrorism, drug trafficking, etc., etc., there are certain crimes which is committed against the children, are committed by the children, that is juvenile delinquency, which is a one level low, very minor type. They feel that children are not able to understand the nature and the consequences of the crime. So, there the investigation is not conducted, rather an inquiry is done and the trial is done by a children court and the children are sent to the observation home. Here I would also like to point out about the Wildlife Protection Act. You see, with the changing trend of society, lot of buildings, high rising buildings are coming and the forests are getting destroyed, the wildlife is getting destroyed. Therefore, the Wildlife Act is enacted, and in that act the forest officers have also been given the power of investigation, but the word inquiry is used under section 52 of the act, and then they have a separate procedure that is altogether a matter of different session. So, I would not be able to cover it here. These all are, I have tried to cover about the investigation. Hope it might have given some information to the listeners. So, with this I would like to say thanks to Mr. Amrendra for giving me this opportunity, and for the audience to have a patience hearing. Thank you very much.
So, well, friends, you heard how the investigation procedure carried out, and what are the salient features, and what are precaution also we need to follow at times when it is a heinous crime or say serious sort of a crime. So I think thank Professor Meenakshi Sinha for giving such an insightful lecture on this very difficult topic in a lucid manner. So it certainly will be helpful for all of you. So and I would also like to thank all of you for watching the lecture. And on your behalf, I thank Professor Meenakshi Sinha. Thank you very much.
So